All rise. The Arizona Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Welcome. This is Arizona Court of Appeals, Division 1, cause number CV130677, Fine Point versus Occidental. For your information, these proceedings are being recorded, and hopefully within a week or so, you'll be able to review the video and audio, if it's all working, on YouTube. So as you approach the podium, please identify yourself and who you are representing. Each side will have 20 minutes for their argument. Appellant, you may reserve a portion of your time for rebuttal. If you'll tell us at the beginning of your argument how much time you would like for rebuttal, we'll try not to horn in on your time. We have read the briefs and relevant portions of the record. We've discussed the case in conference this morning, so we are aware of the facts and the issues. The clock on the podium tells you how much time you have remaining. If you want 5 minutes for rebuttal and it says 10 minutes, that includes your 5 minutes of rebuttal. So with that, we may begin.
Good morning, Your Honors. My name is Kyle Israel. I represent Appellant Occidental Fire and Casualty Company, who I'll refer to as Occidental. I would like to reserve 5 minutes of my time for rebuttal. And may it please the Court, the overriding Arizona legal principle in play here in this matter is that presumption that cases should be decided on their merits. As the Court is aware, this case arises out of a default judgment that was obtained in a coverage litigation that was spawned by an underlying injury litigation between...
But this wasn't a coverage litigation. They filed a breach of contract. They didn't file a declaratory judgment act, and they didn't ask for, court, please tell Occidental that they've got to defend us. They said, you breached the contract.
Correct. They're saying the contract for coverage. I guess we're talking about the same thing. I agree. They're claiming consequential damages as a result of the breach of contract.
Correct. It's not just, make them provide coverage.
Correct. Correct. And on that point, after the parties discussed dismissing the case in return for coverage being provided, dismissing this breach of contract case, there were no indications by Fine Point as conditions following that they wanted to be paid for lost profits in order to dismiss the case. And so that's meritorious defense number one.
Well, but, at least in your opening brief, you indicate that Occidental had retained counsel and had agreed to defend Belfour, I think, as of June of 2012. But if there was an agreement, no one filed a notice of settlement with the court that I saw.
That's correct, and it's not required that a notice of settlement be filed in order for a settlement to be binding between parties.
No, but at least the court notice what's going on and to wait, documents so that it doesn't have to worry about the 150-day rule filing. It can tell you that there may be some sort of default going on, but apparently the parties have settled it, and so we'll see what happens next in a usual time.
I agree, Your Honor. The underlying record shows that there was no notification to the court that in exchange for a dismissal that the Occidental would provide a defense and indemnity to Belfour in the underlying injury litigation which occurred, and it was provided without ever rescinding any of that coverage or any of that defense. Ultimately, all fees were paid, and from Occidental's perspective, even if the plaintiff had continued on, the plaintiff being Fine Point had continued on, they were talking about a $70,000 issue. A $70,000 issue regarding payment of fees back to Belfour's counsel, who was demanding payment of that. Fine Point was not indicating, following that satisfaction of their condition for dismissal, that they wanted some additional monies paid for lost profits. And as the court has probably seen from the underlying record, ultimately the trial judge said, look, we've got to do something with this case, either have a default damages hearing or we're going to dismiss it. And that's what happened. And for the first time, there's this $1 million lost profits claim asserted at that time. And that came after Fine Point was aware that it was no longer going to get work from Belfour because it didn't have a general contractor's license and it was doing general contractor work for Belfour. And notwithstanding, an administrative assistant for Fine Point went in and said, well, we've made $1 million on average the last couple of years. We're not getting work anymore. And that was requested. And clearly those damages have nothing to do with anything Occidental did.
Once Occidental had noticed that the hearing was going to go forward, assuming based upon what's in the opening brief that counsel was retained, why didn't someone show up with an answer that had been filed, or to, as you would be entitled to do, to participate in that hearing, cross-examine?
Well, first of all, the Occidental did not receive notice of the default damages hearing. That is its position. There's a claim that a phone call was made when everything else was in writing to alert them to that, but they were not aware of that, and afterwards became aware of it. But if we look at the history leading up to it, we have in June a request that Occidental, in return for a dismissal, provide a defense and indemnity. That happened in July. In August, Belfour paid Fine Point monies that were past due, that was withholding due to the fact that it was owed attorney's fees. So there was the damages were mitigated at that point. And then 2 months later, an application for entry of default occurs, and then the default damages hearing occurs. So at the trial court level, yes.
Were you not aware of that application for default?
I was hired after the judgment.
No, I'm Occidental.
Yes. Sorry. Certainly I understand what you're saying. Yes, I believe Occidental at some point became aware of that. But they thought it was a $70,000 issue in the balance of attorney's fees, which they had planned to pay. They were in the process of reviewing attorney fee billings. No one was saying, we're going to look to go, at this point in time, we're going to look to go get $1 million. You guys better pay attention to that.
So it wasn't worth their time for $70,000 to show up?
I think it probably was if they thought they were never going to pay it. But at the same time, remember, they believed they had settled the case. And you see in the correspondence a request, a condition. You have to do this in order for us to dismiss. Occidental did that. Occidental was an unrepresented party. Fine Point was a represented party, and they were going based on that condition and fulfilled that condition. And just a week ago, this court decided a case not too dissimilar, KB Homes versus Charter Oak, CACV 12-0681, where the dispute was whether an insurance carrier was required to provide additional insured coverage to a general contractor who had sued a subcontractor. The carriers
Didn't have a default in that case.
No, but it has to do with the actions required in order to reach an agreement. And that's what we're talking about here with respect to the settlement issue. What happened in that case, and I'm sure you're familiar with it, is that the carrier's policy said we don't provide additional insured coverage unless there's a written executed agreement between the sub and the general to provide AI coverage. Well, the court looked at the fact there was no written agreement but said the general contractor issued a letter requesting it. The subcontractor went to its agent and got a certificate of insurance, and those two things together could constitute an agreement, and therefore that was a meritorious issue and remanded accordingly.
You have, I see a couple of problems. First off, you said we're going to agree to represent Belford, but we're going to only do it. We're going to do it, but we're going to we're still going to look at whether we're actually on the hook for this. And then, the other thing that, that your Occidental's person does is they, Fine Point submits a bill for $70,000 and for some attorney's fees, and they don't agree to pay all of it. I just don't see that there's a settlement, because you're still dickering about the terms. So explain to me how you have an agreement with, when you're still dickering about the terms.
First of all, with respect to the reservation of rights letter that is issued in every single, I can't imagine one without it, and I've had over 1,000 of these cases, construction-related cases, a reservation of rights letter where the insurance company says, we're going to defend you, number one. Number two, regarding the indemnity obligation, there may be some things that aren't covered in this case, and we're alerting you to it because that's what the policy states. The request was to provide a defense and indemnity to the extent of coverage, not asking Occidental to throw away their insurance policy conditions and become a blank check. That wasn't requested, and nor was it provided. And so a reservation of rights letter is standard. That was a fulfillment of the extent of coverage condition that was requested. And in fact, they never said, we're not covering this or this or this in the case. Never happened. So there was no breach of that term once they fulfilled that term. With respect to the amount of fees, what you're talking about there is whether they breached the settlement by not agreeing to pay the fees that one side thought was due versus maybe what Occidental thought was due. Ultimately, that was agreed to and resolved and paid.
It was agreed to and resolved, but that was after the default.
Right. That's.
So you're still dickering about the terms.
We're not dickering about terms. We're dickering about what is required to fulfill the terms. It's just like any settlement. Sometimes we get a settlement, we have an agreement, and then for some reason someone doesn't get paid on time. That doesn't make a settlement not exist. That has to do with whether or not you breach the settlement, and someone can bring a claim for that, for damages for that. It doesn't undermine the settlement. It just requires compliance or performance with the settlement. So,
Counsel, even if you thought you had an agreement, and even if you had an agreement, when Occidental receives the application for default, shouldn't it ring somebody to bell, hey, why are they going after a default when we've already agreed to settle this?
yes, as I mentioned earlier, from Occidental's perspective, this was going to get taken care of because it was a $70,000 outstanding issue, and they were in the process of dealing with it. I don't think in the end of this case, it's just or fair to say, well, you didn't show up, so one party gets $1 million judgment as a penalty to you, which has nothing to do with damages actually suffered. And we have cases. We have several cases on Rule 60C6, including one where there was a $25,000 default judgment in Roll versus Jonka, JANCA, 527 P. 2nd, 294, where the court said under Rule 60C6, all they saw was a twisted knee. $25,000 for that? That was not just. And Rule 60C6 is the residual tool left to the courts to vacate a judgment that is not just. And cases should be presumptively decided on the merits. So regardless of whether there was a settlement or not, this judgment doesn't reflect reality. They didn't ask for lost profits during the process of the correspondence following the defense and indemnity. They showed up and asked for it, even though they knew, the party knew they were not getting work for a different reason. So they had no damages due to accidental.
Did Occidental showing up at the hearing and explain that?
Perhaps if they'd known about the hearing. And their position is that they didn't know about it. This seems like the focus is on the process here. I'm talking about a judgment that doesn't stand for what damages actually occurred due to Occidental. That's the bottom line here. And Rule 60C6 says that will not stand. We are not going to allow for that. And that's what we're here to say. Yes, did Occidental show up to everything? No, they didn't. But should the penalty be $1 million judgment that doesn't stand for actual damages? I don't think so, especially since the presumption is deciding cases on the merits.
Aren't we really looking at this 60C, whether there's been an abuse of discretion?
I would say yes if the court if the commissioner at the trial court level had analyzed the issue. She ruled from the bench and never even mentioned.
But that doesn't matter to our standard of review. Our standard review is there an abuse of discretion as it's defined to determine whether Occidental should have been granted relief, not whether, the equities play out in your favor at this point in time.
The court said, number one, the motion was timely, so we don't have that issue. The number two, the court said, I don't see one of Rule 60C elements here in terms of one of the parameters, 60C6 or 60C3. We've demonstrated that 60C6 should apply at least to the settlement issue and 3 or 6 to the damages issue. But the third thing, I think, is what you're talking about, the meritorious defense. The court said, I don't see a meritorious defense. Well, we've demonstrated a meritorious defense. Not that we would win, but that we have a meritorious defense, and that is a basis. If a $25,000 judgment in a twisted knee case was significant enough for the Court of Appeals to find an abuse of discretion, I would think $1 million judgment in a case where we have a party that knows why it's been damaged, it's lost revenue for a different reason, but yet tells the court something else, and the judgment doesn't stand for anything that is just. If there's no other questions, I'll reserve the rest. Thank
Okay,
you.
thank you.
Good morning, Your Honors. May it please the Court, Jason Kelly for Appellee Plaintiff Fine Point Painting, LLC. With me at the table today is my co-counsel, Daniel Warner. From a big picture perspective, I think Judge Portley got it right. This case, or this decision, I believe, is outcome determinative on the standard of review. The standard of review is for abuse of discretion. From a big picture perspective, the senior claim examiner, Ms. Weiss, at Occidental Insurance Company, over a period of 12 months, was put on notice at least 4 times that Occidental was facing a potential 7-figure judgment. At least 2 of those notices came after this reservation of rights letter, which include a August 23rd, 2012 letter with a settlement demand of $400,000 and the January 9th, 2013 motion for the damages hearing, which requested over $1 million, both of which were sent to Occidental. And during that same time period, the senior claims examiner received no less than 5 notices that the default damage hearing was going forward. So when
There's
you
the
look,
indication in the opening brief that at some point in time, Ms. Weiss had retained counsel. Is that someone in Arizona, or she was just, or do we know from the
the
record?
first, I don't think the record's clear on that. I think the first notice I had involved in this case was when Mr. Israel filed the Rule 60C motion 2 months after the judgment. And when we look, and Judge or Commissioner Benny, on the only page in the opening brief from the transcript was the last page, but her decision says, I'm denying, for the motion to set aside the judgment, I'm also denying that motion. While I found that 2 months, given this situation, appears to be timely within Rule 60C, I don't see one of the reasons having been met, nor the meritorious defense. She addressed all 3 prongs. And the 3 prongs, as this court is aware, is prompt action, one of the 6 subdivisions, and meritorious defense. It's interesting to note, and the Richas versus Superior Court case is a really nice segue, because it reads, and I think this is on page 514 of the Arizona Reporter, there's no paragraph markers, but head note 5 says, yeah, we like to decide cases on the merits, but we also have an issue of finality. that we need to address and balance out. In that case, a insurance company had waited 5 weeks to file its Rule 60C motion. And the Court of Appeals, the Supreme Court, vacated, reversed, and remanded the order setting aside the judgment and reinstituted the judgment because it found a 5-week delay without explanation cannot be considered prompt action, and that would be an abuse of discretion. I submit to this court that if there was any abuse of discretion on Commissioner Benny's part, it was finding that the 2-month delay was reasonable. There's absolutely nothing in the record explaining why it took 2 months to file the Rule 60C motion. I'd also submit the Orson versus Martin case. We cited that on page, I believe, 18 of my answering brief, which also held that an unexplained 4-week delay cannot be considered prompt action. Again, if there was any abuse of discretion here, it was the ruling that the unexplained 8-week delay somehow constitutes prompt action. As to the other 6 subdivisions, or the second part, one of the 6 subdivisions, in the brief, we Occidental argued subsection 3 and subsection 6. I'll address subsection 3 briefly. Subsection 3, and the case law holds subsection 3 is only applicable if there's fraud in which the judgment was obtained, the manner in which the judgment was obtained. Again,
Like, you don't have to show up to court, nothing's going to happen today.
something like that. Occidental would like, in point of fact, Your Honor, we mailed them, again, at least 5 times and told them show up, gave them a phone call. It's now Occidental's position they never received the phone call, but there's no affidavit in the record. No one raised their right hand and swore on an affidavit, Mr. Warner was mistaken when he said he called me. And in fact, we have the billing records. So in any event, 3 doesn't apply.
Let's go to in terms of looking, and I don't have the complaint in front of me, but something that at least makes me ponder, did the complaint seek lost profits?
Yes, Your Honor.
Okay.
Paragraph 27 and 28. Paragraph 27 of the complaint reads, quote, because of OFCC's, that's Occidental's, failure to cover Belfour, plaintiff is not getting paid the $3,000 it is owed and will likely be liable to Belfour for an additional $200,000, parentheses, at the very least, close parentheses, given that Belfour has a $500,000 deductible, period. Paragraph 28, quote, additionally, comma, because of OFCC's failure to cover Belfour, Belfour refuses to do any further business with plaintiff, period. However, Belfour is plaintiff's largest source of income. And in the prayer for relief, we ask for the incidental and consequential damages of the failure to provide coverage. Along those lines, in the first letter, the first notice that Occidental received that there was a potential 7-figure exposure was May 24th, 2012. This is when Attorney Warner wrote to Ms. Weiss, and I think he attached a copy of the complaint, and said Occidental could be liable for well over $1 million. There's nothing surprising about this damage figure. This is totally consistent all the way through. Moving on to subsection 6, the case law is that something.
What if the evidence does in fact support the idea that it wasn't really Occidental's handling of the case with Balfour, but Balfour's reconsideration of its relationship with Fine Point for whatever reason, whether it's, I think I heard, not having a general contractor's license as opposed to whatever. But what if it was that? Then this doesn't seem apparently to be a just result.
Well, 2 points, for 2 preliminary points. I'm not sure which one is stronger. First, causation is not at issue at the default hearing, and Occidental agreed with that in its reply brief. So the cause of the damages are not relevant, and all well-pled facts, as I just read to you in the complaint, are deemed to be true. Second, again, the standard of review, did Commissioner Benny abuse her discretion in finding that subsection 6 doesn't apply?
And more importantly, Occidental had the ability to at least file a notice, appear, answer if they wanted to. But if a notice had been filed, then you would have been required under the rule to give 3 days notice of that hearing. It would be more than a phone call.
Correct, Your Honor. The final point I make, the question, what was the cause really? Assuming we set aside the law that causation is not an issue, assuming we set aside the standard of review, there's an affidavit from corporate counsel in Missouri that Fine Point Painting wasn't a general contractor. There's no foundation for his statement. It's filled with hearsay. It was attached to the reply brief on the Rule 60C motion, and they're called Fine Point Painting. This affidavit was created weeks after Occidental finally got around to paying Belfour the money it was owed, which, as I think Judge Orozco pointed out, was a month after the default judgment was entered and sent to Occidental. I mean, the affidavit itself is inadmissible evidence, even assuming we get that far. And so the question becomes, did Judge Benny abuse her discretion in discounting this hearsay-ridden affidavit? You know, I'd submit no. She's well within her discretion. I don't know what the Twisted Knee case was about because it wasn't cited, so I can't really address that. But I will submit that a twisted knee is much less important than hundreds of thousands of dollars in revenue, than an explosion causing a personal injury, a gas line explosion apparently causing a personal injury. I don't know what that case said. I haven't had a chance to review it. I suppose.
If you had a twisted knee, you would understand. Trust me, okay?
Well, I think that's probably enough. I will address the reservation of rights letter quickly. To the extent of insurance coverage doesn't mean please change your denial into a maybe we'll deny later. It means to the extent of the available money. Okay, there's Occidental, and no one at Occidental can honestly believe that reservation of rights letter means that Fine Point can never ever sue them for anything, but they're entitled to litigate against Fine Point for anything. Reservations of rights letter often spawn litigation. The Morris case, the Damron case, apparently this KB case. I haven't read it, but apparently there was a reservation of rights letter, and that litigation got to the Court of Appeals. So, you know, the argument or the suggestion that the reservation of rights letter fully protects Occidental and gives Fine Point no protection flies in the face of the settlement argument. I'd also point out from the original moving papers in the trial court, on page 4 of the original moving papers, Occidental argued, well, we had a settlement with the reservation of rights letters. But they weren't so sure. The next sentence or the next paragraph reads, we had a reservation when we agreed to promise to think about paying your attorney's fees. And then later on page 5 of that motion, it says, we didn't move to set aside, we didn't appear because we were hoping to resolve the issue. How an attorney and an insurance company, and by attorney I mean the attorney on Fine Point's side, I mean how these emails and this reservation of rights letter and a hope to settle the case sometime down the road can constitute a settlement agreement, you know, is beyond me. In conclusion, I again submit that the standard of review is outcome determinative. Can this court say Commissioner Benny abused her discretion? I submit the answer is no, because during this year period, at least 4 times she was put on notice of a potential default. I got my numbers wrong. Maybe it was four times as to the amount of damages, and 5 times that the default was coming.
Oh, you mean Miss Weiss?
Miss Weiss,
Okay.
and Occidental, yes. So if there was an abuse of discretion, I would submit that Rechas and the Orson case are compelling or controlling. That says 4 and 5 week delays in filing a motion cannot be considered prompt action unless you give a reason. There was no reason given here. And unless the court has any questions, I believe I'm done.
Thank you.
Just to respond to some of those points, number one, the standard of review and what was reviewed, whether someone showed up to anything is not a part of that. It has nothing to do with whether or not there was prompt action taken, which the the trial court determined it was timely, and there is no cross appeal on that. And it's interesting that Fine Point would make that the number one thing it would talk about because it knows there's a meritorious defense here. The two reasons the trial court found that there was no vacating of the judgment was because it didn't think that one of the Rule 60C subparts applied, which we've discussed why 60C6 applies. It's very fact-specific, the residual basis to look at a situation like this when someone's getting $1 million payday when they suffered no damages relating to it, and that there's a meritorious defense, and we talked about those. So whether someone showed up or not is not relevant to what the trial court did. So it seems to me that there's this preoccupation with that and a desire perhaps to simply punish a party for that with the $1 million judgment when that's not the legal analysis here.
The complaint, at least from what I appears on the record, the complaint did indicate that the suit was for more than merely $70,000.
Agreed. What the complaint came along, and then after the complaint there was a payment of substantial amount of attorney's fees by Occidental in follow-up to the communications about, look, you need to pay these fees. We need to see this letter of coverage, which they were provided, before we will dismiss. That was provided. Then they said, well, wait a minute, you haven't paid $70,000. Okay, let's look at the bills. That's what happened with that. There was no discussion at all throughout that. But what about our lost profits? You still have to pay that? No, we will dismiss it once we see that you are providing coverage. And by the way, if you read the reservation of rights letter, it says we're going to defend and indemnify, period. These are the provisions that apply. It doesn't say we might change our mind later, anything like that. So they did exactly what was requested. The only issue that was outstanding is the $70,000. So that is, if somebody put their head in the sand and ignored that until too late, that's the risk they took. Not $1 million, because that wasn't even raised. Sure, it was in the complaint. But after they thought they had it resolved, the only thing that was discussed was the $70,000. And regardless of whether it was discussed, and I'm not talking about causation, Fine Point can't come in and say, look, here's our books. We made $10 million last year. This year we made it $0. You can't claim that you can't defend on causation that it's not related to Occidental. We showed two numbers and we did the math. Give us $10 million. No. Your damages implies that these are monies that you suffered due to the assumed to be true allegations in the complaint. Those aren't damages you suffered due to those allegations in the complaint.
I'll be honest with you, Mr. Israel. I just don't see how you had an agreement. And if you can't get past that, I think you had them going back and forth, and there was plenty of notice that they were going to default you. They sent you an application for default. I got to ask, why didn't somebody appear?
Because they thought they were resolving the one issue that was outstanding with the $70,000.
Even though they said we're going to default you, even though they said, and they send you an application for default. I mean, they're telling you we're going to have a default hearing. They're telling you all this, and you're still not appearing. I got to tell you, it doesn't. If you've got an agreement, you don't have somebody telling you I'm going to default you, and now I've defaulted you. And now I'm going to have a hearing. That those kinds of conversations don't happen when you've got an agreement.
Then it's one party abandoning the agreement. We've all had that happen before. That doesn't mean there was no agreement to begin with. But let's even set that aside. Let's talk about the fact that these damages were not related. Belfour made the decision it was terminating. They've told you what the reason is. A declaration is admissible for that reason. Whether they are right about their reason or not, they're the ones who made the decision, and Fine Point knew about it, never told the trial court judge at the default damages hearing, well, they say they fired us for this reason, but we think it's this reason. You decide, Judge. They never did that.
Well, I think that is the risk that Occidental took when they didn't appear. And there was obviously some evidence, and granted it was one-sided, but there was some evidence of lost profits. They didn't get everything they wanted, but they did get a substantial sum. I'll guarantee you that. But I'm just struggling with the agreement.
I understand, Your Honor. I just go back to deciding things on the merits, and this has not been decided on the merits so far. Thank you.
Thank you. We will take the matter under advisement and issue a ruling in due course. Thank you very much for your arguments, and we really appreciated them, and we are adjourned.